Fine. Okay. Right. Consider the following with respect to Article 25, number 1. Right. It provides for freedom of conscience, and practice of religion thank you, of religion in order to exercise individual freedom. Now read. Okay. Article 25 should be read with 26. In order to understand how individuals and groups both can be protected in pursuing religious activities. Next, Constitution does not define religion. Constitution does not define religion. But as per Supreme Court's view, it is a matter of faith. It is a matter of faith and need not be. It is a matter of faith and need not be necessarily theistic. Need not be necessarily theistic. Next, one more. The wearing and carrying of kirpans. Shall be deemed to be included. The wearing and carrying of kirpans, KIRPN, kirpans, shall be deemed to be included in the profession of Sikh religion. Right. Kirpan is that small knife which they carry as, right? So they have certain elements of religion, kesh, kirpan, kada, and likewise, right? Right. Which of the above is incorrect? Which of the above is incorrect? Where 25 gives this freedom, that is there, it's correct. 26 should be read with 25, it's correct to understand this, right? Third statement, it does not define religion, and that is why Supreme Court has said that religion is a matter of faith, right, and need not be theistic. Theistic means it should not be religious only. So third is also correct. Fourth is also correct. It has been accepted as necessary practice, right? We'll talk about it. What Supreme Court says that there should be a necessary practice. What constitutes necessary part of religion and what is the optional part of the religion, right? So there are two aspects of religion. One, which should be considered as necessary, right? The other which is not necessary. So for 6, it has been considered to be an aspect of religion. Right. Now, right. Fine, right. Okay, Article 26. Yogi answers, so none of the above is incorrect. Right. Okay. With respect to Article 26 now. Now you'll remember, you write it this way. Right. With respect to Article 26, consider the following. It gives freedom to religious denominations. It gives freedom to religious denominations to manage establish, and administer institutions and property for religious purposes. Right. The term, next line, the term matters of religion. Matters of religion. Fine. They can manage the matters and affairs of the religion. That is the term. So next line is, the term matters of religion does not only mean matters of doctrine or belief. Doctrines or belief, right? Which extends beyond rituals and ceremonies of the religion. Right. Next line. Okay. It is for the courts to decide. What constitutes essential practices of a religion. What constitutes essential practices of a religion. Essential practices of a religion. What constitutes essential practices of a religion. Next line. Next statement. The right to acquire property for religious purposes. Property for religious purposes must be administered as per the religious doctrines. Which are incorrect. Read it again. See, sometimes information is not just important. Right? Like he said कि भाई 44th amendment, but 44th amendment में जो हुआ वो कभी force में नहीं आया. It has not been brought in force, so it is illogical. First statement. Article 26 provides the freedom to religious denominations to manage the institutions for religious purposes. Correct. Second. So religion here is not only focused on religious doctrines, but something beyond that. It's not just about rituals and ceremonies. That means what? First, to understand, what does it mean? It means that if people are there who claim themselves to be part of a religion, may not necessarily follow the religion, the rituals which everyone else is following. That means I may still be a Hindu and still I may have my own perception of the religion. Right? So is religious dogma or religious doctrine the guiding factor in defining Article 26? No. So see, your sect, your belief, your faith. right? Can be treated independently, right? But yes, you have to show somewhere that it is part of the religious philosophy. Unless you need to claim कि भाई you are a different religion altogether. Fine. तो उसे करने के लिए भी कुछ conditions चाहिए. Fine. You cannot independently claim कि भाई I am a religion. Right? For example, SP Mittal case is there, right? In which these the Aurobindo, the followers of the Aurobindo ashram, right? They wanted to claim themselves as a different religion or different, identity altogether, but they were not given the identity. They were merely treated as part of the sect of the Hindu religion, right? So if you are treated as separate religion, then you will enjoy the protections all available to them. If you are part of a sect of a religion, then you will enjoy the protections which are available to your religion and not specifically to your sect. Fine, ये तो clear है? Fine, ठीक है. Next. Yes, that's correct. It is the court which will decide what is essential practices because it is not defined anywhere. Fine. Then. Wrong. When you acquire the property, you have to administer it as per the law of the land. Fine. You cannot simply administer it. You have to administer it as per the law. Yes, you can make it function as per the religious doctrines. Right? You can perform rituals, do things, whatever. Right? You can create the structure as per the desire of your religion. That's okay. But you cannot say, I will bypass the law of the land and then administer according to my own rules. Fine. So, ठीक है. Right? अब हम. So Article 21 में भी जो choice है, choice or freedom of choice, right? That should also be read with Article 25 and 6. So freedom of religion, freedom to choose a religion, freedom to go to a religion, freedom to convert to a religion, that is your choice. That is also protected by Article 21, not just by 25 and 26. 25, 26 presume that you are religious. Fine? Right? So what can they do? Now another one more question, right? Through this itself you revise it, memorize it, right? Which of the following freedoms are allowed under Article 26 to the religious denomination or sects? Sects. A. To establish religious institutions or trusts. Right? Simple question hai, right? But confusing hai. Second statement, to manage its own affairs. So the state should not encroach into it. Manage its own affairs. To acquire its own property. Third statement. Fourth, all these freedoms are subject to public order, morality, and health. Which of the above are correct? Just give me 1 second. I'll just.
अगर यहाँ पे ओन नहीं होता तो प्रॉपर्टी को गले में जाता ओन प्रॉपर्टी
All are correct. Language.
Religious institution established by the state and managed acquire its own property.
It can acquire its own property subject to public morality and health. Correct. Fine. Next, it got go. Right. Assertion. Okay. Article 26 provides protection to religious denominations or sects. Protection to religious denominations or sects. 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 Reasoning. Religion as a matter of faith. Religion as a matter of faith. Faith cannot be, as a matter of faith, cannot be practiced individually. Cannot be practiced individually. Individually. Statement assertion is simply it is correct. 26 provides for religious denominations, sects, whatever. Right? 20, reasoning says कि religion is not a matter, that is why sects are given. Reasoning independently is incorrect or correct? Incorrect. Why? Because religion or is a matter of faith which can also be practiced individually, need not be the reason or existence of a group for practicing religion. तो reasoning अगर गलत हो गया फिर तो गलत हो गया. Then you know what is the answer. Fine. Next, लिखिए. Which of the following is incorrect? Is incorrect. Number 1. To be accepted as religious denomination, the group must satisfy certain conditions. Next statement. It should be a collection of individuals with common belief or faith. Faith as a primary condition. Okay, Pooja, correct. As a primary condition. Along with the above, there is also a need for having a common organization. Common organization that creates a distinct identity. Then, next line. Right to property for an individual is not a fundamental right. Right to property for an individual is not a fundamental right, but for religious denominations, it is. Fine. But see, this right to property of the religious denomination is not absolute right, just like any other, like many other fundamental rights, right? It's not an absolute right. So if a question comes, the right of religious denominations to have a property is absolute right, that is not correct. Right? But it is a kind of fundamental right. Yes, it is correct. Why? Because it is part of 26 itself. But 26 is a fundamental right. So it is mentioned in that, and so it becomes part of 26 itself. अरे भाई हरीश क्या कर रहे हो फिल्म डाउनलोड करोगे which one who is asking you have that अच्छा कोई बात नहीं बोलो अभी दे देंगे कोई बात नहीं third is incorrect just check हरीश देखो क्या which one is correct no which one are correct certain conditions, correct? First two conditions are correct. Third is also correct. They need to have an organization. How will you be identified? ठीक है, तो अगर आपने बोला कि हम राधा स्वामी सत्संग हैं, तो आप कैसे आइडेंटिफाई होगे? You need to have an organization, एक चैरिटी, एक फॉर्मल स्ट्रक्चर कुछ तो होना चाहिए. Right? Then fourth, then is correct. कुछ भी incorrect नहीं. Fine. That is why I have not given the option. None of them is in. You kindly write it below that. Nothing is incorrect. Fine. Now, see, when we use the term religious morality, when we use the term morality, control or regulate these rights on the provision of public order, morality, health, whatever, right? We can restrict these rights on those grounds. What is the meaning of that word morality here? Now, that is a typical question. What does this morality constitute? See, कौन सी morality है? Religious morality है, social morality है, कौन सी morality है? So you are trying to restrict the right of religion on morality. So that morality will not be religious morality, no? Right? So what morality will it be? Now बताओ. लक्ष्मीकांत बहुत पढ़ा तुमने, बताओ. नहीं. Right? That is called constitutional morality. So Supreme Court has interpreted it as constitutional. That is why between the lines important है. बाकी fact तो पढ़ी लो यार, इसमें क्या है? Between the lines. The questions, right, are asked based on the simple common sense, but it is between the lines. ठीक है? इसीलिए लक्ष्मीकांत क्या करता है? बेसिक इंफॉर्मेशन देता है, बट बिटवीन द लाइंस नहीं देता है. वो बेसिक इंफॉर्मेशन इंपॉर्टेंट है. यू शुड नो दैट. व्हेन यू गो बैक, वन रीड द बुक, राइट? रेस्ट, डोंट वरी अबाउट एनीथिंग. सो व्हाटएवर विल बी द कॉम्प्लिकेटेड एस्पेक्ट दैट आई विल डू, राइट? तो यू हैव टू थिंक दैट वे ओनली. सो व्हाट डज दैट मोरालिटी कॉन्स्टिट्यूट नाउ? तो अब ये क्वेश्चन लिखो, तब ये याद रहेगा. राइट इट सो यू विल रिमेंबर. लिखिए. देखिए, the term morality or public morality, for example, or public morality under Article 25 or 26, 25, 26 likewise. But it can be restricted on these grounds, right? 25, 26 constitute the following. The following, right? A, social morality. B, regional morality. Cultural morality. See, बहुत सिंपल क्वेश्चन है, बट समझ में नहीं आएगा. Constitutional morality. So you're not given option. You're just given 4 statements, right? 4 options, no multiple choice options. So you'll have to be very precise. कि भाई it will seem that all of them are correct. So it seems all of them are correct. क्योंकि religion का ground है, तो social morality भी हो सकता है, right? Cultural morality भी हो सकता है. So this is how they trap you. But precisely it means constitutional morality. Supreme Court ने खुद बोला कि भाई we take on ourselves this responsibility, right? सबरीमला केस में, temple entry case में, सबरीमला केस में, right, yes, that they have viewed this as term as constitutional morality. But there is something, right, that will constitute essential religious practices, but if it violates the constitutional morality, then it will not be accepted. Fine, right? Just below this, you write one line. The term, okay, constitutional morality within the meaning of Article 25, 26 indicates the need for the test of essential religious practices, also known as doctrine of essentiality. Doctrine of essentiality. That is, religious practices cannot undermine the basic intent and purpose of fundamental rights. इसी बेसिस पे ट्रिपल तलाक को भी डिनाई किया गया, पता है? Of fundamental rights. So it is fine, it violates Article 14, it violates Article 17, it may violate something else. But the logic is that if something is highlighted as essential practice, that essential practice must also conform to constitutional morality. Constitutional morality would say that fine, let us have a test, that is it essential for this religion to exist? Right? If it is not essential, then it is violating the constitutional morality. If it is violating it, then we will dominate. Right? Constitutional morality will dominate the practice of religion. So in one of the judgments, like Supreme Court has said, that masjid or the place, the mosque, or the structure of that is not essential feature. या मंदिर होना सिर्फ एक essential feature नहीं है आपके religion के लिए. Right? So for every religion to exist, there are some essential aspect and there are some optional aspect. Right? What happens? The conflict emerges when optional becomes essential. That's a problem. So temple entry, Sabrimala jo movement hai, right? Even if Sai Deepak is talking about the idea that there has to be some unique distinctive features of one's religion, right? And it is not merely discrimination related to women or men or women, right? It is not a gender discrimination that women are not allowed into the Garbhagriha, the sanctum sanctorum of the temple, right? While they are going through menstrual cycle or whatever, right? So he says that normally this is a matter of faith, right? If the Lord is a celibate, right, then probably he does not allow it. But the logic is that whether the existence of that identity of the God is dependent upon this or not. Whether that God will lose the sanctity or this practice of religion will lose the sanctity if women enter the temple. So that would not have been the case. So religion does not require the lack or restriction on the entry of women, right? Religion requires that, okay, something should be followed as a matter of faith in a particular way. But altogether denying the entry of women will not constitute the practice of religion. But it will be discriminatory. What is the ground of that? Right? So logically, like in Hindu religion also, in many of the rituals, right, it is very clear that males have been given prominence over females. Right? Where you have to sit, how you have to act, what you have to do, and likewise. But that does not mean that if we manipulate or we violate these rituals, then the religion will lose its essence. It is not so. लेकिन एक पूजा का रिचुअल चेंज हो गया तो रिलीजन का एसेंस तो खत्म नहीं हो जाएगा. So that is the idea of constitutional morality, right? 27 लिखो. 27 क्या भाई? 27 relates to what? Freedom from payment of taxes for promotion of any particular religion. So freedom from payment of taxes to promote any religion. ठीक, अब बहुत क्लियर, पहले सिंपल चीजें समझते हैं, राइट? So it is for all persons, ये भी क्लियर है, right? Then second is non-payment of tax. So it is not paying tax, but not necessarily. Yes, Pooja, correct. So when you say freedom from payment of taxes, so that word tax will be taken literally now. That means it should be in the nature of tax, not in the nature of fee, right? Or a levy, or a surcharge, or something, whatever you say. So if it is a fee, it's a user charge, then it will not be treated as tax. So that means the government can not impose tax to promote a particular religion and make others pay for it, right? But can government impose fee? Can government impose charge? Yes, it can. Understanding? So tax नहीं कर सकता, लेकिन fee और charges कर सकता है. That is why if the state machinery is used in protecting a temple, Vaishno Devi, right? अब state ने बहुत सारे और benefits create किए हैं. So that does not mean that state is actually promoting a religion. That also means that yes, state can impose certain charges for administrative purpose of that religion. So state is supporting that particular religion, not promoting that. Right? It is only providing the minimum conditions for that religion to perform its functions. Are you understanding? And it is for everyone they will do. Hajj subsidy, right? So obviously there was controversy regarding Hajj subsidy. In fact, it was not a subsidy at all. In fact, right? Government was overcharging. In fact, right? But it was given, right, as part of promoting those people or those sections of the society probably who were not capable of, doing all these tasks on their own. So they were provided administrative support, tour guides, travel agents, and likewise, right? So subsidies were provided. Now 2018 onwards, they have done away with the subsidy, right? That was the issue going on. As one of the aspects of Hajj was that it should be undertaken by a person by his own money, not from someone else's money. तो एक ग्राउंड ये यूज किया गया. दूसरा ग्राउंड यूज किया कि भाई एक्चुअली ये सब्सिडी तो है ही नहीं, because it is charging, a lot of money was spent, right? It was not being that fair. So that was also an aspect, right? Thirdly, that if the subsidy on Hajj would be given, then this money is being taken from majority, then this money is also being taken from other people and diverted to some religion. Fine. So that was also one ground which they used. Then they said that this money will be transferred for promotion and empowerment of communities rather than just promoting some religious practice. Fine. So government has its own ground, may not be considered totally correct because you are providing benefits for other religions also. Fine. So on that ground, so many things can be restricted. Right? But it doesn't matter. See, UP government, whatever you say, but you do not know the numbers. They have just given, I think, 367 some crores for upgradation, maintenance of madrasas. Madrasas. Right? So it's not like that governments do not support, right? But see, madrasa would be treated as educational institution, and that is why, like Maharashtra, they had restricted certain, they had put certain restrictions on madrasas, right? And likewise, so see, the state does not totally detach itself from religion. That is very clear. So non-payment of tax means what? That a specific tax which is focusing on promoting a particular religion that cannot be imposed. And if you deny giving that tax, then you're not doing anything illegal. Then you are protected under 27. Fine, right? But if that is not a tax but a fee or a service charge or a user fee, then you have to give. Then you cannot say I will not give. That means the levy of any other thing apart from tax is not protected under Article 27. Fine. ये समझ में आ रहा है? ठीक है. Now, right, further. It is the money for puja, you know. No, that goes to the trust. That does not go to the government. Fine, you have to understand. Well, see, they are charging fee, so that goes to the trust. The money goes to the trust, right? So generally, these trusts, whatever the trust laws are there, charity laws are there, they give taxes as per that. Right? In fact, they are exempted from taxes. That is why they create it as charity and trust, NGO. They are exempted from taxes. Fine. So even if you puja archana, you give the money, it goes to the temple, not to the government. Fine. But yes, you can say that my trust has given or trust has donated this money for this purpose, right? Now trust says that around the temple, whatever roads are there will be constructed with the help of the trust money. Now government is not taking money directly from them, but trust is willing to pay to the government and say that we are going to support this construction of this wall around the temple, right? Or sorry, this road around the wall of the temple. Now that road can be used by anyone. तो वो तो government को आपने दिया. Government उसको माना नहीं. That is not something legally the government can impose on you, right? But yes, if government is maintaining certain specific amenities around the temple for people, because ultimately they are citizens, for citizens to exercise their freedom, right? That may be considered as administrative cost. Devasthana of Hindu, yes, correct. Even Devasthanas of Hindu temple, they have to be treated distinctly, right? So government has tried to provide administrative support to Devasthanams, but they do not control it, right? There's a very famous case of Supreme Court where the government was trying to, yes, there was some funds. The government was trying to control these funds, but it is not directly to be controlled by the government, right? There is a principle which works. So we use a word. I'll tell you, just don't worry. Fine. We distinguish between the deity, right, the god, and the one who serves the god. So there is a distinction. So whatever is going to the fund of the temple, right, that belongs to the deity, not to the pujari. Shebet. It's called a Shebet, the doctrine of Shebet. So Shebet is basically the one who is working on behalf of the deity, the Lord. Right, puja. So it is not belonging to the pujari. It is not belonging technically to any person. It is belonging to the Lord. Right? And on his behalf, someone else is working as a trustee. So those funds cannot be dominated by the government, right? So they have to follow the procedures established under the charity or the trust in which they are created. Obviously, this was the reason the government wanted to take over the management of many temples, because they had a lot of money. That's very obvious. Right? A lot of money going into the temples. So government, if they administer it, they will control it. But they cannot do it. Why? Because this is where this principle comes. So court says it does not belong to the persons. It belongs to the Lord. Right? Lord cannot use it. For example, Lord Ram 3 times came into the Ayodhya dispute case. But there was somebody who was representing the Lord Ram, right? So you can use this logic. There is something called juridical person. So Ram, yeah, you don't take the Rama as just one individual. You take it that this Rama means the system that you want to establish. So who will represent the system? Who will represent the temple? Right? The pujari or the Lord itself? The temple does not belong to the pujari. The temple belongs to the Lord. So it is the Lord who will represent himself. Through whom? Through Shebets. The Shebat or the Shebets are the people who are supposed to be trustee of the Lord. Fine. So that is a very unique logic. But you cannot, by this idea, by this logic, the government cannot directly acquire the property. Even when you say Ayodhya trust has been created and government is only facilitator for some time. Once the tasks are complete, the trust, everything will be handed over to the trust. Fine. So it is quite obvious that these funds do not get controlled by an individual. It gets controlled by a trust. The trust is working on behalf of the Lord. The Lord owns everything. Fine, Pooja? Is it understandable? Okay, fine. You're right. Right. Article 27, okay, represents essential element of secularism. Essential element of secularism. Secularism. That is, no public money to be spent. No public money to be spent for religion exclusively. No public money to be spent for religion exclusively. Though it can be used for the maintenance of all. Fine. Now, right one. Here the term, okay. Here the term tax also indicates that there cannot be a compulsory provision. Compulsory provision. On the other hand, a fee or a service charge or service, you can say fee or a service or a user fee, they are not obligatory. Right? So see, fees is what? Quid pro quo. I want something, I give and take it. Right? Tax becomes mandatory. In tax, it is not very clear also that specifically individuals ko kya mil raha hai. So you might not eventually use any service, but you may pay the tax. Right? So it will violate your freedom of conscience. Understand? Right. Okay. Next point, kindly write. Okay. Supreme Court has also said that what is forbidden by Article 27 is that specific appropriation of the tax or a specific appropriation of the proceeds of tax cannot be used for promotions of individuals as well as groups associated with particular religion. Right? So see, this way, courts have given various judgments when we commemorate someone's or we celebrate someone's 100 years, 125 years, 50 years, 500 years, whatever. So when we commemorate or celebrate something like that and state provides some administrative support, the court has held this is not to be treated as purely religious activity. Right? So if some Jain guru, right, or his commemoration of his presence or his role is being celebrated, and state provides certain supports, that is not to be treated as the religious activity. It says by persons who have contributed to the culture of society, persons who have contributed to the history of the society. It doesn't mean it will be treated purely as a religious activity. So if you're celebrating Vivekananda's birthday, that does not constitute merely celebrating a religious person. So those things should also be clear. When we are celebrating someone's birthday or commemorating someone's 150 years or whatever, that should not be treated as religious activity. But we can celebrate it socially, nobody will stop it. When state celebrates it, or when state gives a holiday for that, right? That does not mean state is only celebrating that person's religious identity. He may have individual contribution. Guru Gobind Jayanti, right? Or in likewise, many other things you can do, right? So 22nd January, if you have given the half-day holiday, central government, that does not constitute that it is being done only for religious purposes, but it was being done for keeping the sentiments of so many people of this country. You can manipulate it anyway, because you cannot say that I'm doing it for purely religious purpose. Right? So if you say that 75% of the people have applied for holiday, what will government do? So government has given half-day holiday. So it is very difficult to define something purely for religious purposes. Unless government directly starts doing something religious. And even if it does, then government will always say that we are doing this for every religion, not just for one religion. If there is majority and there are minority, obviously number of people also, or the demography of a religion also makes it logical for government to spend somewhere more and spend somewhere less. Government says we are not restricting the expenditure, right? We are not discriminating, but because there is a majority and that expenditure is probably more, and there is a minority and that expenditure is less, so we are only justifying it on the ground of demography and population, not on the ground of religion. Understanding? So अगर government बोलती है नई रोशनी scheme, नई मंजिल scheme for Muslim, for minorities, you can also say कि भाई तो secular based है, but that is not true, right? So when government start evaluating people as backward, educationally backward, right, socially backward, and likewise, so government can use that ground also that we are promoting these schemes, right, for inclusive development, not specifically based on religion. Understanding? तो ये schemes भी तो questionable हो सकती है कि भाई schemes क्यों हैं, religion based schemes क्यों हैं, minority based schemes क्यों हैं, right? But yes, they will protect it. 29 and 30, they will talk about कि भाई yes, the state also has to protect cultural and educational, or cultural, linguistic and educational, or cultural, linguistic and religious minorities, right? Fine. लिखिए, अभी आगे लिखिए. So there was a famous Praful Goradia case 2011, right? In Praful Goradia case, he has highlighted fine. It was highlighted that the Hajj subsidy is unconstitutional under Article 27. So उसके बाद से वो debate start हुआ, फिर 2018 में Hajj subsidy scrap किया गया, right? But the ground was कि भाई this money, or we'll spend a major amount of money for the empowerment of the minorities, education and other things, rather than just religious purpose, right? Let's see, under लिखिए, now one line you add, right? Under various court judgments, right, including Ayodhya as well, the concept of she-bait rights, the concept of she-bait rights have emerged. That is, the property or fund of the temples is owned by the deity or the idol, owned by the deity or the idol as a legal person. Right? Humans appointed on the behalf of the deity, are called as she-baits. And all the offerings which are given to the temple belong to the Lord, right? Not to the she-baits. शी-बेट का कॉन्सेप्ट जो है वो तो क्या केस है, जगन्नाथ टेम्पल का केस हुआ था. इट इमर्ज इन दैट ओनली कि भाई जगन्नाथपुरी का केस था. सो इट इज इन जनरल ऑल्सो द इंडियन जो कॉन्स्टिट्यूशनल फिलॉसफी है दैट फॉलोज द कॉन्सेप्ट ऑफ शी-बेट, though it is not an Indian concept, right? But we, like in Ayodhya also it was raised in many other Devosnam fund, right? The funds belonging to, like mostly in the South India, right? The funds of the temples are huge funds. Yes, Tirupati, likewise. So it started from there only, by whether this fund will belong to the people who are running it, or it will belong to the Lord. So it belongs to the Lord and not to the people, right? If it will be, then it will be appropriated between them. And obviously it is huge money. The government is not taxing them. So what purpose it is being used, right? Who is the authority to use it? On what purpose? On behalf of whom? So that is why Shebet system is created. Okay. So they can only protect, they can only maintain it, they cannot use it. Fine. 28. क्या है भाई? So 28 is basically about educational institutions. So in educational institutions, no religious instructions can be imparted if obviously that educational institution is fully managed, fully funded by the state. Or you can understand it this way, that no religious instruction, no compulsory religious instruction will be provided in the institutions owned and managed by the state. For non-state institutions, it can be, right? Now there are different types of non-state institutions, or let's say state institution means what? The government creates it. The government gives the fund. The government manages it. Fine? Universities, institutions, education, there are many institutions, right? Now, so that is a totally government-owned institution. Here the protection is that people, children, whosoever cannot be compelled to follow religious instructions, a specific religious instruction, right? Because it is owned by the state. So state will not discriminate within its own institution between one religion and another. Right? That does not mean there cannot be any religious instruction. There can be as part of academic study. Fine? But yes, you cannot bring purely, or you cannot compel anyone else to follow that instruction. Fine? Second. Now, institutions or educational institutions, or it gives general protection to educational institutions. Educational institutions can be a variety of types. One, fully owned, managed, funded by the government. Right? Others, funded by the government but not managed by the government. Right? Managed by a different trust, a charity, a system, but funding goes from the government. Right? There also restriction is there. Right? Now, institutions recognized by the government. That means under a government law, obviously every institution has to be recognized by the government. Right? So under any government law, this institution is authorized. Like for example, deemed universities, private universities, they are created under the state laws. They do not belong to the state or to the government directly, right? But they are formed under the state law, right? Registered under the state law, recognized by the state, right? But they may not be getting fully funding from the state. They may be getting partial funding from the state, right? On certain grounds. So there, religious instructions can be imparted, right? But anybody from other religion cannot be forced to follow it. Understanding? So those institutions which are independent but partially funded by the state, right? Or time to time receive some grant from the state. For example, AMU, Jamia Millia Islamia, and likewise so many other. St. Stephen's, the famous St. Stephen's case is there, right? So it was said that it is a minority educational institution with the under the definition of Article 27, 28, whatever. It is a minority educational institution, right? But it is an educational institution. It's not a religious institution. So it's an educational institution, so it can create its own rules, right? Because it is not getting directly funded by the state, but as it is affiliated to a central university, University of Delhi, right? The grants given to the university also goes to them. But they are using a lot of infrastructure of the government, no? Subsidized land, right? Infrastructure, security, many other things, civic communities, basic facilities they are getting from. So it was said that yes, you cannot disallow the people from other religions also, but yes, you can create certain or modify the certain conditions for people from your own community. You can allow them, right? You can liberalize the conditions for them, but you cannot restrict the others also. So if you are creating restrictions for educational purposes to promote your, not just religion, let's say your community values or whatever, right? Then that is not unconstitutional. If you are keeping these conditions reasonable. Fine. So if the conditions are put reasonably under private unaided institutions, private partly funded institutions, or institutions recognized by the government, they can establish certain conditions to regulate the entry of certain kinds of people, right? But it should not be unreasonable. That means you cannot say 100% everybody will be from my community only in this educational institution, right? Then the government funding will have no meaning. Then the government cannot totally recognize it because it will be a discriminatory system, right? But if you're self-funded, autonomous, right, you can put restriction, but then also that restriction should be reasonable because it should not violate 14, 21, 19 and all this. Fine. Okay, that is 28, right? Right, Article 28. No religious instruction. No religious instruction in educational institutions that is wholly maintained, that is completely, right? Wholly maintained out of state funds. Right. But it does not apply to those institutions that are administered by the state. Right? State is managing and administering it. But it has been established under a certain trust or endowment. Endowment is like a fund which is given. Certain trust or endowment. Right. Under Article लिखिए, under Article 28. Under Article 28, a distinction has been made regarding the type of educational institutions. Wholly funded by the state, right? Funded and maintained, you can say that way. Fine. Created under a trust or endowment, right? But managed by the state. Right? So this is administered. Right? So some trust created by, let's say, a person, that person has now left this planet, right? But he created a fund. Out of that, a trust was developed. That trust maintains an institution for women, for example. Now state will administer it. So it was created under this, but that person's willingness was that state can, if I'm not there, if there are no people who are starting this trust or institution, then the state can manage this institution. So state will acquire because it constitutes a considerable public interest, right? Then recognized. When you say recognized, it is not a state, but it is recognized by the state law. Recognized by the state. In fact, all of them are recognized, but as they are directly part of the state, it is recognized by the state, and partly funds are provided. Fine. Then, see, funded, maintained. Created, funded by some other endowment, money from somewhere, but administered by state. Partly funded by state and recognized by the state. Fine. And then private, unaided institutions. Recognized तो ये भी है.
Every institution is basically
Recognized, yes, recognized. But here the word recognized indicates actually that it is not directly owned by the state. So see, recognized. So private institutions have freedom to do whatever they want. It doesn't matter. They cannot, obviously forcing to will be again the fundamental right. But obviously the government cannot impose restrictions on them. Fine, you're right. So there are 4 types of institutions, right? Okay. So if you look at this 2, 3, 4, right? The religious instructions cannot be restricted totally, right? But nobody can be compelled to accept, follow it. First, that is very clear. 2, 3, 4. Second, for minors, right? There can be religious instruction. There can be certain things which may be religious, which may be done. But when the minors are told to do so, they have no obligation to accept it unless their guardian or parents give authorization. So unless the parents give permission, the minor children cannot follow it. Fine. So even adults cannot be forced. Children cannot be forced, nobody can be forced. Right? And now this is also typical. And the institution cannot take this as the ground for removal of the student. Institution cannot take this as a ground for taking any action against the student, because that protects freedom of conscience. 25 of the individual. Fine. So conscience to hai chalo. So this is purely for educational institution. It is quite logical that educational institutions like madrasas, gurukuls, and likewise, they provide some religious instructions. Fine, but they are technically not run by the state. Okay, they are supported by the state, partly funded by the state. Administered means, when we say recognized by the state, we mean they have to run by the laws of the state under which they are recognized. Right? So religious instructions can be imparted, nothing wrong in that, right? But it cannot be imparted in educational institutions which are of certain categories. Otherwise, you can establish a totally religious institution, you can impart instruction in that, right? But then your education may not be recognized by the government. This is also an implication here, that whatever education you are providing, that has to be recognized by the government. If it is not recognized by the government, then whatever you are providing has no commercial value in the society. Understanding? That is also very important. So government is not saying you don't do it, right? Will not recognize you. जैसे महाराष्ट्र लॉ लाया कि मदरसा में restriction कर दिया उसने, fine. It talked about by use of technology, use of computers, and all these things, because state was giving a lot of funds to these institutions, right? So basically, these are created as charitable institutions, right? But there is also provision in the constitution like 29 and 30, right? It has now a different perspective. 25 to 28 gives protection to everyone. It gives freedom to everyone, right? But 29 and 30 recognize that giving freedom to all the religions may become a threat to some. Majority, minority, right? Demography. So when everybody is free to practice, propagate religion, it may create problems for some, right? So 29 and 30, even though we cannot say it is not for majority, it is for majority also. Supreme Court has later retracted from the idea, right? Earlier it was considered to be only for minorities, but it is not true. So it is for everyone. But logic is that, does everyone require that kind of protection? No. So 29 and 30 recognize cultural and linguistic minorities. Cultural also includes religious, right? Cultural may also include majority. Why? Because different cultures or majority religion also may have distinct cultures in different regions, right? Language. So language is also an identity. It can be within the majority, it can be within the minority, right? So many times the language as the basis transcends the religion and the culture. People from different cultures speak the same language. People from different religions speak the same language. Hyderabadi. Okay. So many of the southern states you'll see that people from different communities speaking the same language. Marwadi speaking Tamil. A lot of Marwadis are there in Tamil Nadu, right? So they are speaking Tamil. Yes, Telugu states also. Oh, in general. So you'll find that language becomes a very fundamental basis of associating people. Fine, but their distinct identity in terms of culture needs to be protected. So these two provisions gives a very wide ambit to protect a variety of identities of this country. So 29 or 30 actually secularism ko promote karte hain. Right? They are not against secularism, are you understanding? Even if they are distinctively protecting the identity of unique communities, right? It is promoting secularism. Why? Because secularism will only flourish when everybody more or less has the similar position, similar identity, and similar voice in the society. तभी वो protect कर पाएगा. छोटे से छोटे को भी उतनी opportunity हो, तभी वो protect कर पाएगा. Are you understanding this logic? Fine. So see, 29 and 30 now. Kindly write few things about it. Right. Protection of minorities. Protection of minorities, just right, 29 and 30. Protection of minorities. So whenever the question comes, which of these relates to protection of minorities, 29 and 30? Who constitutes minority? All the religions, right? Who may have distinct identity, right, in terms of language, culture, script, right? Protection of minorities, right? That is the groups having distinct culture, language, script, etc., have the right to conserve the same. Right? Applicable to citizens. 29 and 30 specifically to citizens here, because you cannot allow everyone to have that right, no? Right? Okay. Article 29, clause 2 does not talk only about religious minorities, but it includes all the communities. Religious minorities, but includes all the communities. It further states that no discrimination can be allowed with respect to admission in educational institutions maintained by state, or receiving funds out of state. Funds out of state only on the ground of this is important, religion, race, caste, ये हर जगह है, religion, race, caste, भाई 15 में भी है, 16 में भी है, religion, race, caste. Now this one, language. This is distinct under Article 29, language, or any of them. Religion, race, caste, language, or any of them. So if you remember Article 15 does not talk about language. Article 29 talks about language. So this also provides protection that nobody can be denied admission in an educational institution which is funded fully by the state or partly by the state, right, or which is controlled directly by the state on the ground of religion, race, language, caste, right? So language becomes an important criteria. What does it mean? It also means that linguistic discrimination is not allowed, right, under Article 29. But it also means that under 15 and 16, linguistic discrimination can be allowed. Now from here, we'll understand that. Once we understand this, then only we can understand that. So see, discrimination on the basis of language can be done, right? For example, when you recruit people to lower level of judiciary in a particular state, one of the major preference is the language. That is why lower judiciaries conduct, or most of the functions are conducted in a particular language of that particular state, right? So there's a demand why it is not. Higher judiciary uses mostly Hindi and English, right? Or English majorly, you'll see higher judiciary. But in other lower level courts, right, the native language is used, right? Then a special officer for linguistic minorities can be appointed, right? Mother tongue, religious instructions, school academic instructions or educational instructions at school level, primary level, right, can be given in mother tongue. So that is not discriminating others. That is basically enforcing Article 29. But nobody can go and claim that, see, they are giving instruction in mother tongue and I'm not able to study. Yes. So if that happens, that will not be considered as discrimination. Why? Because it will be for promotion of larger public interest. So 350A, capital A, 350 capital B. Religious instructions can be provided till primary level in educational institutions in native languages, 350A. There should be an Office of Commissioner of Linguistic Minorities, 350B. Right, very interesting thing, Rico. Right. Now first you write Article 30. Okay. Article 30, on the other hand, provides protection to minorities to establish educational institutions. To religious and cultural minorities. Cultural minorities. That means all minorities who are based on religion or culture or language, technically by 29, right? They can establish the educational institutions of their choice. And now see the difference. Just now we said ki 27, 28, you cannot fund, you cannot give taxes for promotion of religion, right? You cannot discriminate on the grounds of this, right? The educational institutions can be established and you cannot be forced to have religious. Now 29 and 30. 30 what it says, that whenever any community, right, religious or cultural, has freedom to create an educational institution for itself, right, the state will not discriminate it for giving funds. That means state cannot discriminate between one cultural institution and another cultural institution when it is giving funds. So under 28, you can have variety of institutions, and state can fund institutions, right? And you cannot force anyone to follow that instruction. Okay? That means state can fund institutions. Understanding? In that, religious instructions cannot be imparted. But what 30 gives? 30 gives the right to people to create their own educational institutions based on their language or, culture or religion, right? And here, the state will not discriminate them when it is giving funds. That does not mean state is bound to give funds. First understand. If the state is giving funds, then it will not discriminate that I will give fund to this one, but not to this one. So 30 is promoting the educational institutions for cultural and religious minorities. State, right, can give funds for that purpose, right? But can state discriminate while giving fund? No, that is the logic. So Article 30 becomes more specific, right? Now, as per this V.N. Shukla, he is also a constitutional expert, right? He says 29 and 30 are not directly correlated. Many books you'll read, they'll say they are correlated. But it's not directly correlated as per his analysis. He says they are not directly correlated. 29 is for a different domain. 29 is for everyone. Whereas 30 becomes more specific. Not just minorities, but yes, it becomes more specific. How are you defining minority? That is important. Cultural minority hai? Religious minority. Right? It becomes more precise. 29 makes it more generalized. No, it's not necessary. Culture may have one aspect as religion. Culture is a broad term, religion is a small term. Culture may have so many other attributes, right? Habits, lifestyle, location, region, right? So when we live in jungle, we have customary laws which we follow. That's a culture. Right? As a religion, they may belong to Hindu social order, outcast. So culture is more specific identity. Religion is more general identity. Right? You write this line first. Okay, the scope of Articles 29 and 30 are not same. Neither they control each other. For example, 29 extends to everyone and not just minorities. Whereas 30 also is not confined to those which have distinct language, script, or culture. But to all religious and linguistic minorities. Right? 30 gives the right to establish educational institutions. 30 gives the right to establish educational institutions, whereas 29 provides for a general right to conserve the language, script, or culture. Individually or all three, it doesn't matter. General, right? 30 religion and culture for how? So through educational institutions. Now see, So here you can conserve it through any means, right? Dance school, drama school, movie, do anything you want. Here it is specifically through educational institution. So state will not discriminate between one religion and another. State will not discriminate between one culture and another. So obviously this promotes more or less all the religions, or this indicates that state can support all the religions. Now this itself indicates that Indian state is not secular. यही तो indicate कर रहा है. 28 indicate कर रहा है कि secular है, but 30 indicate नहीं कर रहा है कि secular है. Why? Because it can provide funds. It is not mandatory first of all, but if it provides funds, it will not discriminate. That means, in simple way, it can provide funds. What funds? Public funds. Understand? So 29 and 30, that is why they are called, technically they are non-secular in nature. Right? Though ये सही है कि दोनों is available to everyone. Everyone means all religions, available to citizens, but citizens from all religions, everyone. Again, you cannot say that it is just minority. No, everyone. For example, I said Hindus are minority in certain areas, so they will get protection under this, right? How do you define minority? Is defined at the union level. The 6 religious minorities, otherwise at the state level, they are also defined. So definition of minority is done at both the levels, state and union level. Right? Under the National Commission for Minority Act 1992, right? It has been defined to have 6 minorities. Then later on, 2006, they included the Jains as minority, right? And likewise. So you can say that defining minority, right, exists as 2 levels, state and union, right? Cultural minorities generally can be defined only at the state level. Linguistic minorities, state level, right? National level, it is different because we don't recognize any language as national or technically as the language of this country. We recognize official languages but not national language. Fine. But state can make steps to ensure that. That is very clear. So if state ensures the protection of language, script, culture, religion, this, or communities can create systems for protecting their religion and state can support it. That means that state in Indian context is not ideal secular state. Even political secularism is a philosophy, right? In practical implementation, it is not there. So whenever somebody says कि भाई राम मंदिर में ये सही था, if they are willing or they are flexible enough to accommodate other religions also, it totally cannot be discarded. Right? 31 we have talked about, 31A, B, C, right? 32 article deals with constitutional remedies or judicial remedies. 32 makes the fundamental right justiciable, right? 32 and 226 they are compared. See, 226 and 32 you can go to the courts to enforce your fundamental right and make them justiciable. To enforce anything you can go to the court. But
so, like for us, Ram Mandir is sacrosanct because it was built before that masjid. So for them, for Muslims, it was built for the first time over there. So it is sacrosanct.
But that is the logic, no? When we say doctrine of essentiality, is Babri Masjid essential for Muslim religion to exist? Right? But Ram Mandir is essential for Hindu religion to exist, even though we say it is not essential practice, but it is essence of our religion. Right? We have dominant source of our religion in those 2 books, for example, Gita हो चाहे रामायण हो या जो भी हो, तो हमारे लिए वो एक essential practice हो गया. No, that is fine. We are not injustice. There is nothing like injustice. This is all political narrative, right? But in reality, it is true that nothing can be preserved forever, first of all, right? And this is not a controversy, first of all. This will be more about mutual tolerance. So there will be, or there would have been religious institutions created under Mughal rule at many places we don't know about. But whatever is essential to our understanding of our religion, right? Whether it is the Krishna's place of birth, now it is part of our normal folk tale, fairy tale, right? Religious understanding, moral values, वो तो हमारे part and parcel है हमारे उसका culture का. तो हमें भी तो right है ना protect करने का, right? है कि नहीं? तो बिल्कुल है. तो हमें भी right है. तो हमने बोला कि basically we are not going to touch upon the specific. अब हम जो कौन है दिल्ली में जो है निजामुद्दीन, ठीक है, हम उसकी दरगाह को answering. So there are certain institutions which are already established, right, which becomes very essential to them. Not freshly established, which are established without creating any controversy for the majority. No, that's true. Nothing wrong in that. right? But yes, that is very true that it should be taken up by the people, not by the state. People are willing to worship there. People need to find a place there. Yes, it is true. If people associate their faith with the particular person, right, and they want to establish a manifest, a symbol for him, there's nothing wrong in that. क्योंकि मुस्लिम रिलीजन में आइडल वर्शिप नहीं है, उनके लिए वो एसेंशियल नहीं है. ट्राई टू अंडरस्टैंड. They may have sentiments as well. That is true, right? But when you are part of a nation, when you are part of a society, you also have to look into the sentiments and feelings of the others. So if the Babri Masjid is emotionally detrimental to us, right? Because it has been probably established by dominating, by eliminating, by decimating our core belief, Lord, or Lord who forms the core belief of the Hindu religion, then they should be accommodative enough to accept it. What is wrong in that? If there was something or a conflict between ki bhai Babar is the originator of the Muslim religion and Ram, so you cannot compare Babar with Ram. Try to understand. Ram has a transcendental position, right? So same way you cannot compare Prophet with Babar. No? They have a transcendental position. So that is also very important, that what exactly you are fighting for. So that structure which was already existing may not be worth it, right? Otherwise everybody will make a structure. Obviously government can acquire the land. Government can acquire religious structures. That is very true. So government can acquire any structure. There is no restriction, right? So government to acquire कर सकता है. Government acquire करे और फिर government बोलेगी ठीक है भाई, we are using it for them. Somebody says make hospital. Why? This is highly illogical. Otherwise you should eliminate all the religious institutions and make hospitals. Why do you want to make hospital in Ayodhya? Understanding this logic? It will be illogical. It will be against the mutual tolerance that we have. Fine. So even for Muslims, that constitutes a part of mutual tolerance, religious tolerance, and even for us, that we are not over demanding. We are demanding something which is rational. Doctrine of severability. A law is made, then will that law be applicable? If that law is against constitution, against fundamental right, then that law as such is not completely applicable. Then what we do? We eliminate a part of the law. It's not eclipsed, it is cut. If it is cut, then that law must be able to be applied. Fine? Then only this doctrine will work. That law can independently exist by eliminating that part. Fine? If that law which is now being applied, right, if it seems to be against, or if it seems to be negative to the constitutional value system, then the entire law will be negated. Right? If the part which has been eliminated, it did not form any part of the, or it does not affect the law anyway, right? Then in the first place, the law that was made was not correct. So there are various grounds on which we evaluate whether the part of the law which we have severed, which we have eliminated, which we have cut, right? After cutting, whether the law which remains, is it applicable or not? This is done when we realize that that part of the law, it can never be accepted as constitutional, right? Under doctrine of eclipse, it is not so. We believe that a part of the law which is unconstitutional today may become constitutional tomorrow, because it was born in different circumstance, right? Severability is used for different circumstance. So severability, you can say, is for all types of laws, but it is mostly for post-constitutional law. Eclipse is for pre-constitutional law. Okay? So
Introducing the Prelims Target course and Prelims test series at ProdEgyIAS. Designed for UPSC Prelims 2026, this comprehensive program offers in-depth classes on history, geography, science and tech, environment, polity and governance, and economy. Stay updated with current affairs and sharpen your skills with our Prelims test series consisting of 50 full-length tests covering all subjects along with CSAT. Join ProdEgyIAS and stay ahead.